what was the client kind of hoping for when they came to you? Obviously a settlement, but what was kind of your lens on what that might look like and what you might shoot for when you started kind of going back and forth with the value of the case?
We handled, so, there's a pre-litigation phase.
Hmm.
We filed a lawsuit pretty quickly on this because we knew it's going to be an uphill battle and we were ready to go to war. I mean, it had to be heavily litigated. And the client, at the time when he was a minor, his father was his guardian ad litem. You need to appoint someone to represent the minor. And it seemed they were pretty reasonable. There weren't any like demands or numbers. And I'll be honest with you, we're very transparent and honest with clients.
Welcome to Just Settled. I'm Dan Taft, the host of Just Settled. On today's episode, we have with us from J&Y Law out of Century City, Los Angeles, incredible personal injury lawyers, Yosi Yahoudai and Jason Javaheri. Yosi and Jason, welcome to Just Settled. We're so happy to have you on.
Thanks, Dan. Thanks for having us.
Hey, thanks. Likewise.
Yeah, and this case today, I'm excited to kind of dive into because it is a unique one. It's not something that we've really covered before. You were telling me some of the details before we got on. I'll let you kind of dive right in and give the overview of what happened and just kind of tell us how you first learned about this case and those initial thoughts, the first things that kind of, came to you when you were hearing the details of this.
Sure. It involved a nice and bright kid about 16 years old at the time of the accident, so a minor. Something that you got to take into consideration with personal injury cases. So I forgot how we got the case, one of our lead, advertising sources, and we took on the case due to the severe injuries. Like I said, this kid was at a charter school and in a class, and he was assigned to a partner to operate some heavy machinery that involved some type of electric saw.
Okay.
And the teacher was not, as he should have been, overseeing what they were doing. And while using this machinery, our client, unfortunately, I don't remember exactly how, but ends up severing off a whole finger, his index finger, I believe on his dominant hand, and the finger next to it, a part of it. And they weren't able to save it, rushed to the ER, obviously got some gruesome pictures. So yeah, my initial thoughts were, okay, is it a public school and it being a charter school? There's no governmental entities to deal with, which can be, different animal.
Right.
Was the professor actually in the class? Okay. The teacher. Okay. What exactly, what type of, the activity is obviously something dangerous. You start thinking about liability, who to pin it on, who's at fault. Is it, California is a comparative fault case. So you can assign, allocate certain percentages of fault to different people or parties.
Okay. It's interesting. Obviously identifying like liability and who's there. Since you said this was a charter school, right? So were there sort of like initial concerns or uncertainties in terms of outcome of this case? Like what were the first hurdles that you knew like this is going to be, a challenge that's unique to this kind of case versus a different kind of PI case?
Sure. So let's compare it to a classic case where things are a little more, clear. An auto accident. Stopped at the red light, boom, you get rear-ended. Liability's, pretty damn clear there. The person who rear-ended you wasn't paying attention and hit you. This is on the other side of the spectrum because you're thinking, okay, well, this is not like a 4-year-old. This is a grown man, essentially. Yep. 16. He's a teenager. He knows that it's, something sharp. It's dangerous machinery. Could a jury come back and say, no, yeah, the teacher's there, but he should have known? They may say, oh, it's common sense. Like, be careful. It's your own fault for that happening. Maybe they think the friend is at fault and it's not the teacher. What did he do to contribute? Were they goofing off? Were they not taking it seriously? All these things, like were they instructed to do certain things? Was safety equipment provided to them or not, et cetera? And so, we roundtable it. We have teams here and we start analyzing, first and foremost, facts of the case, how it happened, and liability. But you also balance the severity of the injuries and other factors as well.
Yeah, that makes sense. In terms of restitution or expectations for restitution, what were you like? were you seeing this as kind of, I know there's a whole spectrum of like how these kind of cases are valued. What was the client kind of hoping for when they came to you? Obviously a settlement, but what was kind of your lens on what that might look like and what you might shoot for when you started kind of going back and forth with the value of the case?
We handle, so, there's a pre-litigation phase.
Mm-hmm.
We filed a lawsuit pretty quickly on this because we knew it's going to be an uphill battle and we were ready to go to war. I mean, it had to be heavily litigated. And the client, at the time when he was a minor, his father was his guardian ad litem. You need to appoint someone to represent the minor. And it seemed they were pretty reasonable. There weren't any like demands or numbers. And I'll be honest with you, we're very transparent and honest with clients from the beginning. We tell them, generally speaking, within a week or a few days of a case, it's impossible to tell you case value, even a range, and what you're going to net in your pocket. It's humanly impossible.
Mm-hmm.
So we don't do that. As time went by, even before the lawsuit and throughout what's called the discovery phase, which is like the due diligence part of litigation, things got more clear with liability. Clearly your finger's gone for life. Right. And so you're thinking, well, this poor 16-year-old has his whole life ahead of him. So you have to think about that too. We started realizing, I was like, look, we shouldn't settle this for anything less than like a very high 6-figure or, 7-figure case.
Yeah.
Just given all the pertinent facts.
Yeah, no, that makes sense. And in terms of, I know we kind of touched on before, like hurdles or opposition. What were some of the normal kind of obstacles and opposition that you encountered that you knew you would run into in this case? And were there other things that were a little bit unique to it or that were more unexpected that you said, oh, this is going to be a bit of a different kind of challenge or a different kind of obstacle that we're going to have to kind of overcome here to kind of navigate this?
Yeah. So I personally wasn't the one litigating the case. We have one of our teams on it and litigation teams, but some of the obstacles that could come up are during what's called, deposition. But you depose, for example, the principal, the actual teacher of the class, and you're just like, well, what are they going to say? Who are they going to try to point the finger at? Like kind of like what I was saying in the beginning. And then there's the written discovery portion too, where you want to pin down and have them admit to certain aspects, of liability and etc. It went pretty smooth. I mean, the litigator on it is a bulldog, and he brought his A game for sure on this and really contributed to the settlement. And they did not, Yos may know, but they didn't file what's called a motion for summary judgment.
They did not, no.
Yeah, right. So the defense has a very plaintiffs too, but generally the defense will can bring a motion for summary judgment is a very, very powerful tool in California, which they bring that motion, and if it's granted, we have a chance to oppose it. The case is done. Like judge dismisses it. Bye. And then, costs have to be paid. It's a very time consuming and very serious thing. And they did not file one. I was a little surprised, but that's great. And to be honest, sometimes they just throw everything at you, but the kitchen sink and see what will stick. They didn't do that. I can't think of any specific hurdles. I think our team really did a good job, and they knew from the get-go, we set the tone that, hey, we are fully confident in our client and their case, and we're going to make you pay, and not just pay, but pay something we feel he deserves.
In terms of the timeline of this case, Yosi, maybe you can kind of speak to some of this here. In terms of like start to finish, when you first learned of this to when it closed out, what did that look like? How long did this run? Yeah, just like what did that timeline look like?
That's a good question. So Jason alluded to this earlier that we filed the lawsuit shortly after getting retained. Some other cases, we don't do that. Just we don't want to put the client through a longer process, incur some more costs for the client, et cetera. But there are certain cases where you just know that an adjuster is not willing to offer what's just in a informal setting. Those kind of cases, which would have more, intricate legal issues, fact patterns, they require the case to be litigated. So we didn't want to delay that any further. So shortly thereafter, we filed. And, depending on which county you're in, some of these courts are very backed up with trial dates. And a trial date is really when the pressure finally applies on defendants to finally settle or take the case seriously. So depending on where you're filing, if you get a trial date 2 years away, which it can happen, you're in a bad spot. I mean, it doesn't affect the end result of the
Right.
case, but it can delay the time of the settlement. Fortunately, here it was normal. I think the trial date was a year after we filed the lawsuit, and we just, and of course, the plaintiff is always in control. So if the plaintiff just sits on, does nothing, the needle never moves,
Mhm.
and the case doesn't settle. But if you're
Right.
aggressive, send out discovery right away, written discovery, take all the depositions, notice them, file your motions to compel if you need to, things will start moving. I think this settled about 9 months after filing the lawsuit, which
Okay.
we're very happy with. Yeah, it's not too bad. We've had much longer situations. So I would advise that to people, that if you know this is a complicated, nuanced case that is going to require a lot of attorney critical thinking, or just that type of involvement, file sooner than later. You're just delaying the inevitable.
Yeah. Yeah, no, that makes sense. And you said obviously 9 months after you filed, is that around the time that you realized that a settlement, like at what point did you know that a settlement was likely to happen versus them trying to push to court, that you knew like they're going to settle?
Early discussions with counsel gives you an idea. If
Yeah.
they're puffing their chest, they're throwing out the words motions for summary judgment, MSJ, you then get the sense that, okay, this is going to be heavily disputed. But if they never bring up any issue, if in their responses, if you serve a request for admission and they admit liability, then okay, it's just the damages question. It's how much, are they willing to offer? It's not, are they willing to offer anything? So this was a case where they weren't really disputing liability too much. It was just, what is just for this young man. So we knew that it was a matter of proving the damages,
Yeah.
how this affected his life. So I thought we were pretty confident that they wouldn't want to try this case. It wouldn't, it's not a good look for them, for the school district, etc. So we thought that it would be in the 9 to 12 month range, about, which
Okay.
it fell into that.
And in terms of negotiating with them, with the school or whoever you were going up against, how did that negotiation process unfold? I know that, defendants are always trying to minimize compensation or lowball whenever they can. How did you advocate for your client's interest in this case?
I mean, the same way we always do, we try to put ourselves in the client's shoes, and how we would feel if that injury happened to us.
Mhm.
It's a lot of communication with the client. A lot of times it's going meeting with the client. It's staying with them, living with them for a day or two, depending on how severe the injuries are. But we're the voice of the client, right?
Yeah.
We're the David against the Goliath. So, it's being in that position of the underdog and just fight, and making sure that, nothing is left off the table. And that, of course, with the client's consent, we come to a number where we believe it's fair, just, it gets the client as close to back to where they were before the accident, helps them with future medical care, compensates them for any future pain and suffering. But it's a case by case basis. There's no two cases are the same, and the approach is not the same for any case.
Right. And Jason, you mentioned earlier that when you were first kind of, looking at what this possible value of this could be, you were saying high six figures, seven figures. This was a case that you wanted to obviously kind of shoot for, a larger settlement for the client. What was the final outcome of the settlement, if you can speak to that, and how did that positively impact your client's recovery? And, they were so young, their life kind of moving forward.
Yeah, we actually settled it for what, our target case value range was. There's never really a single number. Generally speaking, we have a case value range, and we obviously want to be at the top of that if possible. This case settled for 1.3 million. Client was ecstatic, very happy. His father too, as well. He walked away with a very big chunk of money, and in such a good age, and it will take care of his, there's the non-economic damage, as we say, the general damages, all his pain and suffering, embarrassment, obviously medical expenses were taken care of, his future medical expenses for any follow-up type treatment that the doctors recommended. Said he needs, I mean, he's set in terms of anything related to the accident.
Yeah.
And then, and whatever's left to enjoy and spend for, however way he wants, really. When you're in
Yeah.
California, you're entitled to damages, and we do our part. What you do with the money is none of our biz. So,
Of course. Yeah.
but yeah, and he'll be able to move forward and live out the rest of his life. And he's so young. I mean, again, he's probably now just turning maybe 19 now.
Yeah.
Yeah. That is an incredible, really good, obviously, number that you guys got him. I'm sure they were very fortunate to come across you to represent them. And again, just for anyone, looking for an incredible attorney here in LA, Century City, personal injury, J&Y Law, Yosi and Jason, thank you so much for joining us on Just Settled today. Can you tell our audience how they can find you if they, want to reach out, have any questions? What's the best way to kind of find you
Of
guys?
course, we offer many options. Of course, you can go to our website, which is jnylaw.com. Call our toll-free number, 877-735-7035, or download our app, which you can get from homepage, and communicate that way. We're available 24/7, email, text, phone, all that fun stuff. We're on social media, online, pretty much everywhere. So we're pretty easy to find.
Awesome. Awesome. Well, again, Jason and Yosi, thank you so much for being on Just Settled here today. And, we hope to have you back soon. So
We would love that. Thank you, Dan. It was fun.
Yeah. Likewise. Thanks a lot. We love that.
Thanks, man.